Hi everyone, welcome back to yet another exciting session for Ignite, where we discuss a very important career option in the legal field. Today we are in a conversation with an Arbitration Counsel, Ms. Chinmayee Pendse. Ms. Chinmayee is a dual qualified lawyer specializing in cross-border commercial disputes under English and Indian law at the chambers of Ms. Karishma Vora in Mumbai. With 7 years of experience, she has represented clients in ad hoc and institutional arbitrations seated in London, Singapore, Dubai, and India under the auspices of the LCIA, ICC, SIAC, and the others. Prior to moving to counsel practice, she has worked as an associate at Vidhi Partners, a boutique dispute resolution firm in Mumbai for 2 years. She is an alumni of Government Law College, Mumbai, and has a dual master's in international business law from London School of Economics and Political Science and University of Mumbai. She is also a member of the Chartered Institute of Arbitrators, United Kingdom, and serves on the core committee of CIRB's Young Members Group in India. We welcome you, Ms. Chinmayee.
Thank you for having me, Jhanna. It's a pleasure to be here.
So now that we've read your bio and we've understood that you have an extensive practice in arbitration and cross-border dispute resolution, would you please tell our audience as to what exactly is arbitration and cross-border dispute resolution?
Jhanna, arbitration is a kind of an alternate dispute resolution mechanism, which broadly refers to a method of resolving disputes without litigation. There are various kinds of alternate dispute mechanisms, such as negotiation, mediation, conciliation, and arbitration is just one of them. In an arbitration, two parties decide that any dispute between them will be adjudicated by an independent entity or a third party who's called as an arbitrator. An arbitration can either have a sole arbitrator or a panel of 3 arbitrators nominated by both parties. The arbitration agreement, which is typically referred to as an arbitration clause, is usually contained in the main contract between the parties. However, the parties may separately agree to arbitration after a dispute is arisen by what is called as a submission agreement. Any decision that is given by an arbitrator is called as an award, as opposed to a judgment of a court. And this award is binding on both parties. Now, this is the basics of arbitration. And when you compare Indian domestic arbitration to an international arbitration, what happens is in an international arbitration, either one party or both parties are from different jurisdictions, therefore giving it an international element. But the basics of arbitration do not change.
All right. So just to follow up to this, like you said that for international arbitration, there's some international element, but is the procedure of arbitration or resolving disputes through arbitration any different in India and abroad?
Arbitration in India is an ever-growing phenomenon. And in India, majority of the arbitrations today are still ad hoc arbitrations, because institution arbitration, so an arbitration that is governed by the rules of an arbitration institution, is fairly nascent. So what happens in an ad hoc arbitration is that the arbitrators use their own procedure. Therefore, each arbitration is slightly different and there's no uniformity of procedure as such. But in international arbitrations that are seated abroad, say in Singapore, London, or Dubai, the arbitration is slightly more established because it's institution-centric. So therefore, there's lesser room for discretion for the procedural aspects. And if you speak just about practice, the pleadings in an arbitration that is seated abroad or in an international arbitration, the pleadings are far more detailed and structured, unlike verbose pleadings that we file in arbitrations in India. Also, this is my personal view that arbitrations are generally slightly more efficient because adjournments are rarely granted abroad. Skeleton arguments, which are like written submissions, they're filed in advance of the final hearings and not later. You file arguments before the hearing as well as after the hearings if the arbitration tribunal wants it in international arbitrations. Also, arbitrations abroad tend to embrace working with technology far more than the arbitrations that are seated in India. So the final hearings, for example, which also include cross-examination, tend to have what is called as live transcription. So everything that is argued and all of the questions that are put to the witnesses, they're all transcribed in real time, as opposed to perhaps a steno typing the questions and answers in a domestic arbitration. So I think these are just little differences in terms of practice and procedure between how arbitrations are conducted in India and abroad.
That's very interesting to actually understand for students also, that disputes can actually be resolved outside the courts, which is something which was not heard of for a very long time in India especially. So now that we've spoken about how arbitration is such a niche area of law and it's ever growing, like you mentioned, what is it that led you to pursue arbitration, or why do you think students should pursue arbitration, which is or what makes it so special?
As trade and commerce grow globally, increasingly companies are looking towards arbitration as a better option for resolving their disputes as compared to the traditional litigation system, which sometimes tend to take more time for adjudication of disputes. So sophisticated, complex, high-stake cross-border commercial contracts usually tend to have these arbitration clauses, and therefore pursuing a career in arbitration will provide you with an opportunity to do premium commercial work. Also, as a junior, you're able to experience a life cycle of a dispute from drafting pleadings through to interim hearings and trial in a relatively short period as opposed to court litigation, because an arbitration is conducted in a time-bound manner. So if you're a student who has dreamt of being a trial lawyer, then arbitration will provide you with more exposure to cross-examination and trial as opposed to doing court work. My greatest joy of working abroad is, I think, the diversity of matters that land on my desk. The international hubs of the world, including London, Dubai, Singapore, have matters that come to it from all over the world. So today, as a cross-border dispute specialist, a solicitor in England and Wales and an advocate in India, I have worked on matters with parties from all over the world, such as Hong Kong, UAE, Israel, and Singapore. And the culture and the commercial mindedness in each of those matters are very different from each other because of the differences in jurisdictions and how a matter is approached by different parties in their own jurisdiction. So I think that's one of the highlights of my experiences of working in international arbitration and cross-border disputes.
That sounds super interesting, that the diversity that comes with it. So we've spoken about arbitration abroad. Could you throw some light of how arbitration looks in India, and what is the judicial approach been when it comes to arbitration and cross-border dispute resolution for that matter?
I think in the past decade or more, Indian legislature and judiciary have done a tremendous job in making India a pro-arbitration-centric jurisdiction, and they have actively followed a path to encourage arbitration. If you know, the Arbitration Act was amended in 2015 and then later in 2018 and 2019 to include strict timelines for completion of arbitration proceedings. The Act also created an institution called an Arbitration Council of India to promote and encourage arbitration and other alternate dispute mechanisms, to grade institutions and recognize professionals who practice arbitration. Also, the judges have over time allowed a broader scope of arbitration of disputes, and generally the challenges to arbitration awards have been looked at with greater scrutiny, and only those awards which are absolutely patently totally illegal or against the public policy of India, they have been set aside. But the judges have been quite mindful about not entertaining any challenges which do not fall within the parameters of Section 34 of the Indian Arbitration Act.
So we have now got some understanding of what exactly arbitration is and cross-border dispute resolution is. But coming to your personal life and your suggestions, what colleges do you think offer this kind of specialization?
Jana, when I started law school, I did not think that I would today be somebody who has a niche in practicing cross-border disputes and has a career in international arbitration. So that is not how I planned my career. So the opportunities came my way, and it so happened that I started enjoying work on arbitrations. My journey, in fact, started with a moot in law school. So definitely, I would suggest students that you should take up courses in arbitration which are offered in law schools. Also, there are universities abroad and also in India who give a specialized master's degree in arbitration. So universities such as MITS Geneva, Queen Mary, Columbia, Pepperdine, all of them have specific arbitration-centric masters. And I think the students would just need to figure out which of these universities and which of these courses suit their own circumstances and their long-term goals. But a master's in international arbitration is certainly something that they can do after their graduation to have a specialization in international arbitration and cross-border dispute.
Okay, so now that we have a greater understanding of the masters pertaining to arbitration, just an information for all the students that it is also offered in UG courses across all universities in India, because that's a mandate as a course of alternative dispute resolution. And now that we talk about masters, and I've read in your bio that Chinmayee, you've also pursued your masters in this similar field from London School of Economics. So if you could tell us how your experience was like and how did that boost your career towards arbitration?
Jana, my experience at LSE was one of the most enriching experiences of my life, and it truly broadened my horizons because I think just spending time with people from different cultures and different academic backgrounds really enriched and my thought process and urged me to think in different directions. So imagine if you're in a cohort of 350 people with just 3 Indians, and in a classroom of 20 students when you're the only Indian and the same point of law is being debated between 20 others from different countries who have different cultural and academic backgrounds. So it sort of propels you to think in different directions. Also, I think I made friends, for life in that program. So now like if I need a lawyer, say maybe in Peru or in France, I can just pick up the phone to a friend of mine. So I think a master's abroad gives you global networking opportunities, and it's also excellent for personal and professional growth. So that is my takeaway from my master's abroad.
So clearly the decision to pursue your master's has actually added a feather in your cap. But for students which are currently in their law school or are planning to join a law school, what are your thoughts as to what they should do during this time if they are interested in a career in arbitration so that they can actually have a successful one in the future?
I think moots, definitely. That is one thing I would highly recommend, because the long hours of research that I spent at the GLC library taught me many things about areas of law I did not know existed. So certainly mooting is one way to go. I would also recommend students to write research papers around the topic. So that would enable them to read and be updated about the latest developments of what is happening in the the field of arbitration, which is something that they can complement with their undergrad course. Also, you can apply for arbitration-focused internships. So either with law firms who have arbitration work, or perhaps an arbitral institution. So I'll give you an example, I think, as to why I think internships would really help. Because when I was in law school, I realized that I really enjoyed studying, say, intellectual property. But when I interned, or company law, but when I interned with corporate teams doing due diligence or transactional work, I understood that my calling was more commercial disputes and going to court, as opposed to doing transactional work. So internships sort of help you decide what you don't want to do, even if you don't really understand or take away from the internships as to what you enjoy doing. I would also recommend looking up courses on arbitration, which are generally privately offered, because that would supplement your undergrad course as well. While I was in law school, I did a diploma in cyber law, for example, but while it taught me many things about cyber law, I was at least able to rule out a specialization in that field. So if you do a course on arbitration, it would really help you to understand the nuances of the subject. Also, maybe you'll realize whether or not a career in arbitration is something that you want to pursue. So certainly pick that up. I would also recommend attending arbitration conferences that happen in your city. So a lot of arbitration institutions host conferences on topical arbitration issues once a year. So perhaps you can just see if there's anything happening in your city or nearby, and you can attend those. So yes, those are a couple of things that I would recommend students to do while they're in law school, so as to build their CVs to a more arbitration focused career subsequently in life.
So just a follow-up to this, if you could just give some names to our students as to what are these law firms who pursue arbitration, either domestic or international, if you have any.
Dharna, there are all of the tier 1 law firms such as SAM, CAM, Trilegal, AZB, Khaitan. They would all have arbitration matters. Even mid-sized and small firms today, no firm can escape NCLT work, which is the work under the Insolvency and Bankruptcy Code, or arbitration work. So if students can just look up these firms, perhaps write to the partners that they're applying to, or the HR, asking who are the dispute partners and whether there's an ongoing arbitration, and then hopefully they'll receive an answer, and that would help them decide whether or not they want to do an internship.
That sounds really interesting, and like you correctly pointed out, I think arbitration is all over currently, either when it comes to individually counsels practicing the same, or law firms. Nobody has been able to stay away from arbitration, both domestic and international, and it really seems a very, very interesting field. So my last question to you is, what are the thoughts that you want to leave our audience with, and the students who are thinking of pursuing this as a career, or have not thought but could give this as an option?
A lot of students come to me, Jharna, to ask this question, and they're generally very stressed about whether they'll get placed, or whether they're not getting internships and how to go about it. And they all come to me with a set idea of what they want to do. But I think my own career path has sort of taught me that it's okay if things don't work according to your expectations, because maybe something else and something better is, right around the corner for you. So don't be fixated on one aspect of law or one type of job. Accept every opportunity that comes your way, and have faith that what is best for you will eventually fall into place. The practice of law is very rigorous, and it consumes all hours of your days, weekends, evenings. I have survived in this profession only because of my love for the law. So definitely be passionate about what you're doing. And if I can leave you with one advice today, is that be a generalist in your younger days. In the practice of law, very rarely you will find a brief which asks only one aspect of the law. So often a commercial law brief may have an insolvency angle or a tax angle. So if you're a commercial law specialist, but if you've done a moot or as a junior you worked on, insolvency or tax matter, you will be able to do justice to your brief in a better way as compared to somebody who's only accepted one kind of briefs or only done one kind of matters to begin with. So experiment in your younger days, and life will then slowly present more opportunities in one area as compared to others, and you will end up where you need to be. Everything that comes your way right now, accept those opportunities and don't be bogged down by your peers' careers and how they're going. So even as a law student, if somebody else has gotten an internship and if you don't have an internship with that firm or in that area of law, don't be bogged down by everybody else's journey. Forge your own path, and things will happen when they have to at the right time.
That's such a nice thought, because I think all of us who've been through law schools know this, that what you start with it's never the same as what you thought of. So I think it's really, really nice to have this very beautiful thought from you. Thank you so much for sparing time and doing this for us. It was truly a pleasure, and hope that you also enjoyed yourself.
Absolutely. Thank you very much for having me. And I'm always available to anybody who needs any mentoring or if you have any questions.
Yeah, that's great. With this, we come to an end of yet another exciting session of Ignite. For more such career options in law and to know more about other things such as law schools and the different subjects of law, please stay tuned to our IMS GSL YouTube channel and subscribe to the same. It was a pleasure meeting all of you. Bye-bye. Thank you and take care.
Thank you. Bye.